enjoyed lunch. I hope your suggestions were collected. Apologies in advance for my voice. So this panel follows up on the State and Municipal Strategies panel by addressing the limitations on public action. We've heard today about some limitations already: physical limitations, financial limitations, technical limitations. One important limitation is political will. These strategies, of course, can't be implemented without elected officials like Senator Blumenthal taking leadership, ideally with public support. But there are legal limitations on these strategies as well. One of the most interesting and important limitations is the takings clause, which says in very simplified terms that private property can't be taken by the government without just compensation, by the government for public use without just compensation. It's now well settled that regulations that reduce property values can, under certain circumstances, usually involving a balancing test, be considered takings. And it's the contours of these circumstances that our panelists will be addressing. So we're going to move from the big picture to the small picture through three very interesting papers. And we start with a bird's eye view of how takings can apply to climate change adaptation strategies. And our presenter for this first paper is Jason Hill, a graduate student who specializes he's a graduate student in the Department of Public Policy at UMass Dartmouth. He's worked on this paper with Professor Chad McGuire, who's seated to my right. He specializes in environmental law, policy, and science. Professor McGuire also leads the Division of Environmental Policy at the Center of Policy Analysis at UMass Dartmouth. So please join me in welcoming Jason, and I think you're ready to go here. Cool.
Okay, get situated here. Okay, I want to first start by thanking our hosts for having us here today and their interest in our paper. I know a lot of hard work goes into putting these conferences together, so thank you to everyone who made this day possible. I also want to personally thank Chad, who I know as Professor McGuire, for the opportunity to contribute to the work I'm presenting here today, and for his tremendously valuable guidance throughout my studies at UMass. So I can't thank him enough. With that said, I know our time is limited, so I'll try to be as concise as possible, with the intention of highlighting the major points of our analysis in a way that everyone in the audience is able to follow along. So the purpose of our article was to review how the role government takes in choosing a climate adaptation strategy can impact regulatory takings analysis. There are exceptions, but for the most part, we're used to seeing states use regulatory strategies as the basis for their coastal management programs. And so our hope for this article in today's presentation is really just to advance a dialogue that can help government authorities think about their available roles beyond regulator when engaging in coastal planning. Stepping outside this traditional role of regulator can yield significant benefits for all parties involved. Number one, the public, by ensuring that policies implemented to adapt to sea level rise are equitable. And number two, the government in terms of limiting takings claims. So before we go into more depth about the different roles of government and their influence on takings analysis, I'd like to take a minute to review the different adaptation strategies that can be applied along the coast with an emphasis on their ramifications in takings analysis. So in general, when we think about how best to respond to rising tides, and I'm sure this is sort of a refresher from this morning, we're confronted with a range of options from inhabiting the shoreline and armoring against the rising tide to essentially pulling back or retreating from the advancing shoreline. So here we have a private residence along the shore and the advancing sea. So as I just mentioned, one policy direction we can take in the setting is to stay and armor against the rising tide. From a takings perspective, it's very important to understand that by choosing this option, government is essentially being mandated to adopt a specific role. And this is largely because the approval for building private armoring structures, in this case a seawall, is adopted through a permitting process that's controlled by local land use authorities. Connecticut's regulatory system is set up this way, and that local land use authorities have the final say in this permitting process, at least when it involves an activity within their jurisdiction. But without getting sidetracked here, ultimately what we have here is local and state governments acting in their regulatory role when reviewing applications from private landowners. Now, in contrast to armoring or other protective strategies, an alternative policy direction is to retreat from the shoreline and allow the impending sea to take its natural course, while also allowing people to move landward away from the threat of an advancing coastline. Now, the regulatory nature of retreat strategies can vary quite a bit. Policies such as minimum setbacks or various forms of developmental restrictions certainly contain regulatory characteristics, and the ultimate enforcement of these kinds of restrictions will almost undoubtedly impact private landowner expectations. However, there are other forms of retreat policies that are less regulatory in nature, especially when rooted in a stance that focuses on the government's role of property owner or trustee. We'll get into more detail about these roles in a few minutes, but to introduce a means to this policy idea, and again, a reminder of what we talked about this morning, rolling easements, which a lot of people will look at this option as a win-win situation because at its core, it allows development, but the risk of loss is shifted from the public to the private landowner. So before we get at the heart of this takings analysis, it's important to take a step back and review the constitutional framework behind coastal land use planning, which, when we think about it fundamentally, is really just a relationship between private and public interest. Where at one end of the spectrum we have the Fifth Amendment, the prohibition against the taking of private property, unless the government is able to demonstrate a public purpose and provide just compensation, in which case the government can use its eminent domain power to purchase property. I'm sure most of you here today are familiar with the eminent domain process, but to put this back into today's context, a good example of this strategy would be buying programs where the government essentially goes out and purchases sensitive coastal areas. But the overall point here, without getting sidetracked again, is to remind everyone that the Fifth Amendment provides this overall protection of private property. Whereas at the other end of the spectrum lies the 10th Amendment police powers to regulate, in this case land use, of course, for the general welfare, morals, health, and safety of the people. When we place the Fifth and 10th Amendment on this spectrum, we can see the distinction between the government directly taking private property, using its eminent domain power, and government indirectly taking private property by infringing upon private property rights through regulation, which, point being, can ultimately result in regulatory takings claims. So, we've established the main limit placed on the 10th Amendment police powers derives from the takings prohibition found in the Fifth Amendment. It should also be clear that the government's power to regulate property and the limitations placed on those powers by the Fifth Amendment creates this sort of tug of war on the extent of power the government has in regulating land use. So over the years, the courts have tried to decipher the property rights between public and private parties, but the resulting case law has been approached very cautiously by the courts. And so we have three categories of takings claims here, all of which have been categorized or defined by a regulatory stance taken by the government. More traditional takings claims tend to focus on physical occupation of private property. This was the case in Loretto, where the government was allowed to sustain a permanent physical occupation so long as it met the requirements of eminent domain. So analyzing this category of takings, where the government is acting to physically occupy the property, is much clearer than a regulatory takings claims, where the government has been accused of taking through regulation and therefore does not actually possess the property interest of the private landowner. So in these next two cases, Penn Central and Lucas, the Supreme Court tried to identify the difference between a police power regulation that does not require compensation and when such a power reaches the point where a regulatory taking will be found. In Penn Central, the court used the evaluation criterion to determine the extent of diminishing property value as a result of the regulation. Now, what's important to understand about these evaluation criteria is that they suggested a balancing test to determine the outcome. But what was left unresolved, and this is very important, was an understanding of what facts might tip the scales towards a regulatory taking rather than a constitutional exercise of police power. This was discussed to some degree later in the Supreme Court decision in Lucas, where And Lucas, the owner of a developable piece of coastal property, was prevented from developing based on a regulation by the state agency responsible for protecting coastal resources. The private landowner challenged the new regulation on the ground that deprived him of all economic use of his property. The Supreme Court recognized the state's regulations through police powers, but ultimately limited this power by indicating that a regulation that removes all viable economic use results in a regulatory taking. Now, what's interesting about this decision is that the court identified a major exception, stating that the only way the state may resist compensation is if they prove that the prescribed uses were not part of the private landowner's title to begin with. So, in other words, if we break this down, it becomes clear that the court is focusing on principles of the state's property law and nuisance already in place. And what's even more interesting, and one of the main points we want to make here today, is that there are other common law traditions and principles in property law that specifically apply to coastal issues. They include the state's proprietary interest and also its obligations as trustee. Now, these background principles of property law can help us categorize government conduct in coastal issues such as sea level rise. So, if governments can help the courts analyze takings claims by identifying their conduct, or what we refer to as the role the state adopts when instituting a policy, direction, or action, we're able to define the basis for government activity, whether that is a regulatory basis for defending the coast or a rights and obligations basis for defending the coast. So if we go back to the government acting in its regulatory role and return to this continuum where the 10th Amendment police power is at one end and the 5th Amendment police power taking is at the other end, we can begin to think about the kinds of regulations that might result in regulatory takings as opposed to the kinds of regulations that might reflect background principles of property law and therefore be well within the traditional police powers of the 10th Amendment. So states can also try to insulate themselves by enforcing background principles of property law through legislation or regulation, an obvious example being when a common law public nuisance is codified by the legislator. But overall, I hope it's becoming apparent that interpreting the government's role of regulator is much less clear from a takings perspective, especially when the policy deviates from common law traditions. Why is this? Well, advancements in science have allowed us to better forecast the impacts of sea level rise, but, and this is very important, this kind of information is not going to be available under traditional common law. Therefore, if the government chooses the role of regulator, it has to ultimately rely on the court's ability and willingness to upgrade traditional views to include more forward-looking risks to the public, like climate change. And as we might expect, the courts are having some trouble doing this at the federal level, and thanks to the work of our colleagues at Georgetown Law, wherever you guys are, we've learned that the courts are having an especially difficult time doing this at the state level here in Connecticut. So again, it may be beneficial for the government to avoid these challenges by looking outside of its regulatory stance. More specifically, we are suggesting as an option a strategic defense against takings claims that encourages coastal planners to take a preliminary stance based on direct ownership rights of submerged lands and public trust obligations. So if we take a step back here and we look at the big picture, we have three basic roles the government can take. Number one, the role of regulator, which we know can trigger regulatory takings and is most likely going to require the government to defend its regulations to exist outside the regulatory takings precedent pointed out a few minutes ago. And then where I'd like to spend these last few minutes, number two, the state's proprietary interests of submerged lands, and number three, the state's public trust obligations to defend the rights of the public within and around the water resource. So, to better illustrate the state acting in its proprietary role, we've set up this scenario that clearly shows the government's ownership of submerged lands seaward of some defined boundary. For Connecticut, this boundary is the high tide line, and the private party's ownership rights landward of this boundary. Now, in the past, these public and private interests could coexist with little conflict, but in a world where sea level rise is occurring in a nonlinear fashion, these interests will continue to become more frustrated as this demarcation line moves. So in the event that littoral landowners choose to pursue a strategy that negatively impacts the government's ownership, coastal policymakers may wish to strategically take advantage of their role as property owner to achieve a policy goal of removing the public from the ocean zone of influence. So, of course, that decision should be left to the authorities charged with defending that specific coast. But the point here is that, if nothing else, this stance can offer a resolution that puts both parties' interests on equal footing when being judged from a takings perspective. I know I'm running out of time here, but very quickly, I'm sure most of you are familiar with the government acting through its obligations as trustee to enforce public rights in the coastal zone, traditionally navigation, commerce, and fishing. But skipping to what's important here, public trust doctrine defense varies by state, depending primarily on the extent to which the state has developed its public trust interest. But broadly speaking, it's important to understand that when the state acts as trustee, its actions are deeply rooted in background principles of property law and can therefore be linked back to the original trust obligations. So, in other words, the state can rightfully argue that it's carrying out its discretionary duties as trustee, much like my previous arguments where the state adopts the role of property owner. But in the end, we have this very important conceptual distinction between the state choosing to regulate versus exercising its rights and obligations on behalf of the people. So, to wrap this up, regulatory takings issues are complex, especially when the goal is to implement forward-looking adaptation strategies in response to coastal climate change. But hopefully, for those of you here today, and anyone who gets a chance to read our article, which you've really just heard a snapshot of today, we'll continue to think about the state's roles outside of regulator as a means to mitigating these complex interactions. At least from a takings perspective, we believe this approach is likely to offer a better foundation upon which policy for adaptation strategies can be implemented. And also please keep in mind that we're not necessarily suggesting that these approaches will limit takings challenges from aggrieved littoral landowners, but we are suggesting that they will limit the likelihood such challenges will be successful in a court of law. So, thank you all very much for listening, and of course, we look forward to answering any questions you have after today's presentations. Thank you.
Professor Karp has conducted research really all over the world. It seems like you've been almost everywhere, regarding, and very broadly speaking, humans' relationship with water and our protection of coastal resources. She's been assisted on drafting the paper by Charlene, who's again sitting over to my right, as a student at Brown focusing on environmental studies and political science. So please join me in welcoming Professor Karp.
I want to thank the organizers, who are also friends of Sima and Joe, for helping to doing our part to mitigate climate change by keeping the room quite cool. It's nice of you. And I want to very much thank Charlene, who's been my partner in this project for quite a long time. And just to give a slightly better introduction for myself, when I first came to Rhode Island, which was the ocean state a long time ago, my first job was defending the state against the Fifth Amendment challenge, so against the takings challenge. We won it. And so I actually been working on Fifth Amendment cases for a really long time. So it's fun to get to apply that body of law to this situation. Now, what I'm showing you here is, of course, the state of Connecticut, and I want to emphasize that it is a water-based state. So you have lots of rivers here, you have a long coastline, and what's going to be really important is I want you to watch this little pink house. And this is a very famous little pink house from London, Connecticut, and the arrow shows its approximate location on the Thames River, and I'm going to come back to this little pink house. But for the purpose of this conversation today, I want you to picture yourselves as people who live in the coastal zone or people who have a public interest in what happens in the coastal zone. So first of all, a water-based state. And so some of you will have played this game when you were kids, and this kind of silly game where you play scissors, paper, fire. What I learned as a really young child is water always wins, period. Water wins. Water beats fire, it erodes rocks, it corrodes anything human-made, it wins. And that is true in Rhode Island and in Connecticut as well. So if I show you that map, in fact, the risks that Connecticut is going to face will not just be sea level rise. The predictions with respect to global climate change include sea level rise that may be 1 to 1.5 feet by mid-century and from 3 to 5 feet by the end of the century. But the projections also suggest more intense and more frequent extreme weather events such as Irene or the bizarre ice storm in October, or these bizarre kind of drought-like conditions in January, February. And in addition, these kinds of events are going to be accompanied by saturated soils. So the whole state with this very riverine environment, you'll have wet land on the upland and being pounded by the ocean on that side. So I want to suggest that the state is going to be exposed to water in a lot of different directions in the form of precipitation, sea level rise and erosion, and also saturated soils on the inland that are going to affect what happens on the coast. So, as I suspect a lot of you know, the two-storm panel just gave its report to the governor on January 9th, and it gave a report on the cost of the Hurricane Irene and also that ice storm, and suggests that the cost to Connecticut was between $750 million and $1 billion. That same group reported to the governor that were Connecticut to face a Category 3 hurricane, which is not a very intense hurricane by some standards, the state of Connecticut would face a $54 billion price tag in the coastal zone based on properties that are in the A and V at-risk zones today. Now, and that's an issue. So one might say here that in fact it's going to be a lot less expensive to mitigate than to adapt. I want to give Charlene a huge amount of credit for putting this graph together. This graph shows projected change in sea level rise at New London and Bridgeport. It does give the range of modeled alternatives here. The high end is a 5-foot increase in sea level at New London and Bridgeport. These are data coming from a variety of different sources, so you're not going to, it's a composite, you're not going to find this graph anywhere else. And the low end of the range is about 3 feet or 1 meter by the end of the century. So I'm going to break the rest of this talk into 2 parts. There are really 2 questions. So what is a state like Connecticut going to do to address existing coastal development? These are properties that already exist in the coastal zone and perhaps in these firm AV zones. So these are properties that are in fact likely to have a 1% chance of experiencing a flood event, really a flooding event, every year. So 1% chance. And that means over the 30-year lifetime of a mortgage, that property will experience a 26% chance of a flood event. So if there are some insurers in the room, and I believe there are, that's an important figure. These properties in the A and V zones will experience a 1% chance each year of flooding, 26% chance of flooding over the lifetime of a mortgage. That does not count storm surge. The V zone and VE zone refers to those properties that are in fact exposed to surf damage over time. And because of the previous talk, which is going to save me some time, I want to point out that the top image shows an exposed septic system. This is an exposed underground sewage disposal system. To me, and to anybody here who is a local official and a state official, you want to have a big neon sign that says public nuisance. This is a public nuisance when you have a septic system lying on a beach. The bottom photograph is an aerial photograph from 1938. It shows what was going on at Mesquamacut Beach, just slightly to the north of New London after the 1938 hurricane. And that red arrow points out the Palazzolo property. And so my guess is we could come back and talk about Palazzolo, who took his case up to the Supreme Court because he thought he had a buildable parcel back there, thought it made some sense to fill in something like 18 acres of tidal wetland. So case 1 is what do we do with existing properties? And then the second case is what can state and local governments do to address people who wish to develop in future high-risk areas. So current development and future development. And I do apologize, but I want to stress this to everybody in Connecticut. You can see Long Island here, right? which looks like it protects the Connecticut shore. Looks like a buffer. U.S. Geological Service just released a report last fall, I think in November of 2011, and it says that Long Island is eroding from north to south. It's losing a lot of sand from Montauk and eroding it down toward Jones Beach and Fire Island. It's something at the worst end of it is 20 feet a year. That's the worst. Now on average it's about 1 foot, but if you imagine that parts of Long Island erode away, it means that places like New London then face direct coastal action, direct tidal action, are no longer buffered at all by Long Island. So I'm not going to repeat this. This is handled very well by my predecessor. We actually have some constitutional bases for the government to act. We have the power of the state to basically protect public health, safety, and welfare under the 10th Amendment. We also have the government's authority, and this is a state common law doctrine. We have this rule that says states control or trustee of these trust resources, submerged lands, shores of the sea, and they hold those properties in trust for all citizens. So you have these two very powerful rules that the state can use to leverage what it wants on the shoreline. And with some tension, we also have the Fifth Amendment, which says, and I'm going to reinterpret this deliberately, the government may take private property as long as it pays just compensation, right? Government may take private property as long as it pays just compensation. Private property for public use, by the way. More importantly for here, sorry, I do want to skim ahead here, something I used to teach with is this wonderful, simple, apparently simple 2x2 matrix, which basically lays out non-market-based techniques and market-based techniques for trying to solve the problem of retreating from the shoreline. This is how we're going to deal with, how we might deal with existing development, but also prospective development. And I want to point out that this simple 2x2 matrix applies to government as well as the private sector. The insurance industry can use the exact same matrix to come up with regulatory strategies and market-based strategies to accomplish common purposes. And the power of this 2x2 matrix is you can start to couple public and private sector options to get really powerful ways to solve problems. So if I do that, and I'm obviously not going to go through these boxes, what I'm going to suggest to you is we have a whole group of options we can bring to bear on this problem of development in the coastal zone. And what I want to suggest is we make choices between and among these options based in part on the urgency of the situation, based on information, based on technology, political pressure, and so on. So at the far right, to your side, we have information-based techniques for disclosure. Those are really simple. They don't require very much. That's really using existing Connecticut authority to require property owners to use real estate disclosure forms and realtors to use those forms to disclose risk of flood, inundation, and erosion at the point of sale. Now, in fact, you have a really good disclosure form. You ought to take a look at Florida's. It's a bit better. So Florida's gone a bit farther. But disclosure's easy. We ought to be using the land evidence records as a way to record some of this information. I was trying to get the firm maps for Connecticut, and it's almost impossible to do online. That's kind of silly. Right? Really, it's a public database. It ought to be really easy for somebody to go in and say, here are the properties that are designated in A and V zones, and I understand the property owners say that will reduce the value of my house. I want to point out the Fifth Amendment doesn't say you can't reduce the value of land. It says you cannot take private property for public use. There's no harm in basically identifying the risks attached to that property. Now, in the United States since 1982, we have had a very strong preference for market-based techniques, really relying on the power of the market to accomplish what we want, as opposed to regulation, which I'm calling command and control. And so there are a lot of market-based techniques, some of which could use taxes, some of which could use tax subsidies to accomplish moving people or to accomplish changing behavior for people who are currently occupying the coastal zone. And then we have these regulatory techniques. So here's the question. So what can Connecticut actually do to change the behavior of people who are currently living in the coastal zone? And at the top you see the picture of a little pink house that was Suzette Kilo's little house that was bought back. I'll come back to that later. And at the bottom are these beautiful cottages that are sitting right basically on the verge of the ocean in Rhode Island, on a beach that I walk on quite a bit. So the question is, can the government acquire these properties under the Fifth Amendment for public use and pay just compensation? The answer is obviously yes, we can. There's just really no barrier to that. However, there are 32,000 properties identified as being currently at risk, like these properties, in the state of Connecticut alone. That's not affordable. I don't think most states would say that's a very prudent reaction to adapting to sea level rise, but yes, you could do that. So then how do we go about incentivizing private property owners to assume the risk of living in what is an extremely risky environment? We can do all sorts of things. We can require disclosure. Local governments can absolutely have the authority, and I've checked Connecticut law, have the authority to impose risk-based special assessments. We do it in the reverse. We actually give use-based tax incentives to people who, for example, set aside land for conservation purposes. It's obviously possible to have a risk-based assessment that reflects the city and town's actual cost to respond in the case of flood disasters, inundation, cleaning up after roads get flooded, and so on. In addition, the state, in working closely with the insurance industry, could require or in fact prohibit access to state-supported insurance funding to help back up in the case of a flood or any other kind of damage, erosion damage or storm damage. So in theory, the state and local government, state government could require property owners in certain zones to hold certain kinds of insurance or prohibit them from acquiring it, so they have to take 100% of the cost themselves. In addition, in a strategy that's been used in other environmental areas, development in the coastal zone could be conditioned on a performance bond where the property owner basically has to put together a bank account that in the event of a catastrophic loss, that money becomes available to help the state and local governments clean up after the public nuisance created by the damage to that property. And then, this was addressed earlier, can governments condition rebuilding after major damage? A number of states have done this. They have statutes that say after over 50% damage, we are going to limit or condition rebuilding on compliance with new building codes and setbacks and set in place rolling setbacks. So this is also a possibility. And I just highlighted all those. So okay, I actually very strongly believe no problem trying to incentivize current property owners living in the coastal zone to assume more of the risk that they are at because of sea level rise and changes that might come along with global climate change. But now the question becomes, under the Fifth Amendment, it's an interesting one, is whether governments can regulate or prohibit development of property in these high-risk areas, even if it results in diminution of value, some loss in value. And the answer, again, is categorically yes. Fifth Amendment says nor shall private property be taken for public use without just compensation. We have a long list of U.S. Supreme Court decisions written by Justice Scalia that say categorically removal of all economically beneficial use essentially means 99.9% of the value of the property. So any diminution, don't worry about that. And I encourage local governments to have some courage with this and to deny or basically to approach some of these strategies. I moved to Rhode Island during the Anticelli decision. So does this mean, can the state require and either require or acquire setbacks and rolling easements? And the answer is absolutely yes. And an interesting one, because the federal government does this, could Connecticut actually limit its responsibility to rebuild public infrastructure in some of these areas? So for instance, say we've got a repetitive loss of this road, this applies in Rhode Island. Repetitive loss to this road, can we just say we're done paying for it? We're going to abandon this road. COBRA does that. So under the Federal Barrier Beach Act, the federal government says we're not going to pay a dime toward rebuilding infrastructure here any longer. Not to federal transportation, not to anything to rebuild in a barrier beach that's subject to repetitive loss. So I would say these are perfectly viable. So then the hard question is, can the government act to regulate these private properties as future development, so people who own land and wish to develop land in the coastal zone that might be these areas that are exposed to flooding, inundation, storm surge, erosion, high erosion areas, even if it results in loss of all economically beneficial use. And I'm going to take this sort of extreme stand here and say absolutely yes with respect to property below mean high tide, which is protected by the state or managed by the state for the benefit of all citizens. And the language that gets used is often the state owns this land. Well, that's not quite right, but that land is held in trust for all people. And that does mean that the state can actually prohibit development below mean high tide to protect submerged lands in the sea and the shore of the sea for citizens. I also read all of the recent U.S. Supreme Court decisions, and that's Lucas, Palazzolo, Stop the Beach. The federal government has, or the U.S. Supreme Court has said, I believe quite clearly, that under certain conditions, governments may regulate private use of private property, even if it takes away all economically beneficial use under certain conditions. One of those is if it is a public nuisance that would have been thought of as a public nuisance at common law. I want to direct your attention again to the idea of having a septic system on a beach. By the time you have a property sitting on the beach and it is elevated above the sand, its wastewater has to go somewhere, its water supply has to go somewhere, the infrastructure delivering energy to it has to come from somewhere. That doesn't have to work like that. We can prevent public nuisances like that. It's actually quite easy to start to address what a public nuisance might be. This is my diagram of the takings clause. I believe the government can act, not just to basically get people to assume responsibility for their own behavior who live in these high-risk areas, but also to limit development in these areas. And my friends basically advised me that I've reached a certain age now, so that it's fair for me to say, here's what I do. So here's what I do. I actually think it's really expensive to adapt to climate change. We're committed to a certain level of sea level rise. We're committed to a certain level of extreme storm events. We're committed to a certain level of inundation of soils that will cause us all sorts of problems with drinking water supply, but nevertheless we need to continue to mitigate. It's going to be cheaper to mitigate in the long run than to adapt. I believe that we need to use these disclosure mechanisms. They're cheap, they're easy. You think that you need to protect the people who own the land, you need to protect the buyers. They're our citizens too, so they need protection, and that means get the real estate disclosure law, get the real estate disclosure form so that it gives buyers something to make a reasonable decision about. Record it in the land evidence record. Simple, easy. These have to include disclosure of erosion risk, not just flooding risk. Absolutely can't just live with that. I believe that we ought to be talking to the insurance industry about requiring property owners to pay risk-based premiums. We have to stop spreading this risk amongst everybody who pays homeowners insurance. Doesn't make any sense. People don't get the signal. It's a moral hazard. I think a lot of people in the room understand that. We have to do away with that. The alternative is to prohibit access to insurance so that people are forced to take that seriously. I do believe we ought to be thinking about performance bonding. That's another way to get private actors and public actors in the coastal zone to take those responsibilities seriously. There are all these relatively easy actions like rolling easements. Easy, I say easy, but it's, that's not fair really. I actually think we can do some really interesting things with buying erosion control easements, so that what we've done for years with buying conservation easements, start to apply that with respect to buying the vegetated inland area from these marshes, so that we allow some room for marshes to move inland. And lastly, it's sort of something we perhaps ought to think about, is we're really looking at quite serious change in hydrology in southern New England, in fact, all of the Northeast, everywhere. And we probably ought to be talking about some kind of a coastal growth boundary where we simply say, seaward of this line, we really ought to limit the density of development. And that's partly because the risk that's been created here is that there has been a 60% increase in population density in Connecticut's coastal zone between 1980 and 2000. And it's predicted that that rate of increase is going to increase by another 30% unless Connecticut does something to intervene. That's increasing the exposure of the insurance industry, increases the exposure of the state to liability in the event of disasters. We ought to be acting proactively to say, ideally, we want a growth boundary, and we want a receiving area for these transfer of development rights that are well inland, so that it's possible then to create positive incentives for developers in the coastal zone to have increased development densities away from the sea. So here's the little pink houses where I end. There's a Kilo's little pink house. I just wanted to tell you a cool story, which is this little pink house started in one place in 1890, and then in 1893 it got moved to the Thames River. And after that U.S. Supreme Court decision, that I'm sure everybody in the room knows about, the person who helped renovate this cute little pink house essentially picked the little thing up and moved it somewhere else, which happens to be a lot safer. And so another message is we could be starting to think about how do we build in a way so that we can actually pick up and move ourselves in the future. Thank you so much.
Our second paper really builds on our first paper. We're going again from broad to narrow. Particularly appreciated the recommendations section of this presentation, and it's a reminder to you all, if you haven't submitted your recommendations to our ideas box, please continue to do so. And for this panel, of course, please write down your questions for our students to collect, and they'll be roaming around as they were in the first panel. Finally, we are honing in now, even again, narrower and narrower focus here on Louisiana to consider how lessons learned there can be applied here in Connecticut. The third paper was written by a student at Georgetown Law Center, David Lewis. He was a former researcher and GIS analyst. He couldn't be here with us today, but we're very lucky to have his faculty supervisor, Professor Jessica Granis. She teaches a clinic at Georgetown in the Climate Center, and she also serves as a staff attorney there. So please join me in welcoming Professor Granis, who's presenting on David's behalf.
One thing I wanted to start by saying is thank you to Sea Grant and thank you to University of Connecticut Law School. I have rarely in my short career seen an agenda that has students participating with local governments and state governments, especially on these really important issues. And I know for my students, it's hugely beneficial for them to work on real-world solutions to this huge problem that we're all facing. And David actually wasn't one of my students. He was in a climate policy class that the director of the Georgetown Climate Center teaches. It's a 2-unit class. He works a full-time job, and he's a full-time law student. And he did this case study in this class. He built on it for this group of people because he knew how important this information is for our state and local clients. So it's pretty amazing. So I'm going to talk to you today about a mechanism for funding retreat. I think with some of our flying houses and our disappearing houses, we can be downplaying the real social aspect of retreat, which is that there are actually people who live in this house and this is their community, and so it's a hard question to ask of people to pick up and leave their house and their community coming from someone whose parents live on a very vulnerable peninsula in Long Beach. But with that, I'm going to talk about So today I'm going to talk about the Hazard Mitigation Grant Program, which is funded through FEMA. And David looked at 2 case studies at post-Katrina. One was a case study in Louisiana, which was more of an ad hoc buyout program that was volunteer, homeowner selected, raising their hands, I want to be bought out, versus an approach that was taken in neighboring Mississippi, which was more of a long-term strategic planning process where there wasn't actually any buyouts on the ground. We're not, passing judgment on which is better, just some lessons that you can glean from both of these jurisdictions in figuring out how you would, build these processes in advance so that when the disaster hits, God forbid, it's probably going to happen, that you have those systems in place so that when you're distributing these funds, you're doing it in a way that really builds the resilience of your communities post-storm. Sorry, I'm challenged. So we've all got a pretty good dose of the problem. You have vulnerable development, you have to balance that with all these sensitive natural resources that we all care about that are held in the public trust, and how do we balance these two interests? The proposal, in a lot of cases, the only successful example of retreat is through these acquisitions and buyout programs with existing legal structures. This has been one of the only real ways that we've managed to address this very challenging area. So I'm going to talk to you about Louisiana's process as compared to Mississippi's. So acquisition, we also had a lot of this, but the pros of acquisition are in, as Tony was saying earlier today, in some areas of our coast, we're not going to be able to afford to build ever higher protective structures and ever higher structures. We're just, in reality, we're going to have to retreat from some areas of our coast. Part of that is driven by the environmental benefits and ecosystem services provided by those lands. Part of it is just the necessity of having versatile and scalable approaches to deal with the uncertain impacts of climate change, and acquisition has to be, and buyouts and retreat has to be one of the strategies amongst the tools that you're considering. And one way to think about how to make retreat an easier process is to think about how you can, as Professor Karp was saying earlier, how you can create market mechanisms to encourage redevelopment in upland areas. One of the problems in New Orleans was that there was such great devastation to the housing stock, there was really no place to move. So thinking about how you can couple redevelopment with retreat and how you can rebuild that housing stock in a way that helps people move inland. Some of the cons we already discussed, these have real impacts to real people and real communities. You have high upfront costs. There's technical barriers in terms of the sea level rise issue as being a sea level rise adaptation as to how you target those funds and prioritize properties for acquisition based upon their vulnerability, and also based upon how useful that land is in terms of, can you restore it for flood buffer purposes and create resilience for inland communities. And then we also talked about some of the constitutional barriers. Along with the takings question, you also have to pay just compensation. So when you're dealing with a buyout program, one of the big issues is what qualifies as just compensation. So just a little bit of background on the Hazard Mitigation Grant Program, which is what I'm going to talk to you about today. There's actually 5 hazard mitigation assistance programs that FEMA administers. Most of them are reactive programs, or after an emergency release, emergency declaration, your community becomes eligible to receive these funds from the federal government to help you rebuild. But many of those programs have similar criteria that I'm going to discuss today. These are federally distributed funds, but they are often administered at a state and local level. And one of the uses that you can put this money to is acquiring and relocating properties. But the big issue here is it's a voluntary program. You cannot use hazard mitigation monies to do eminent domain. It has to be a homeowner who raises their hand and says, yes, I want to be bought out. There are certain eligibility requirements that limit who can participate and who can't participate. And then there are limitations on, once you've taken these federal funds and you've administered your buyout program, you have to lock that land up for open space. And you have to actually acquire the land, and that then imposes certain management responsibilities on the local or state government who assumes those properties. So, let's talk about Louisiana. So Louisiana received $1.2 billion in hazard mitigation grant money, and they coupled that with some community development block grant money. It was administered in a state administration process called the Road Home process. And homeowners who were eligible to participate in the Road Home program had three options. They could rebuild in place, they could sell but stay in Louisiana, and they could sell but leave Louisiana. And I think the distinction between the option 2 and 3 really is an issue of tax base, because with these acquisition programs, one of the cons that I didn't talk about is that tax base that all of the local communities rely on to support their services. Once you buy those properties out, they are no longer paying taxes. So it can be a huge upfront cost and then back-end drain on the public fisc. And the third aspect of the program was that it was administered by a private entity. There was a $150,000 cap on any of the eligible programs. You got deducted in any insurance premiums that you got paid out. And then there was a pretty complicated 12-step review process that I'm not going to get into. So here are some empirical results. About 10% of people chose the buyout option. Those are the numbers. So what does he want me to say here? Sorry. So one of the big kind of perverse incentives of the Louisiana program were the people that opted for the buyout option were often undercompensated as compared to the rebuild and in place option. So they weren't actually compensated for, the full value of their property, which might have, contributed to this 10% level. Another interesting aspect is that there was a huge spatial distribution about who opted to be bought out, and I meant to look this up as to why, because David didn't put it in the notes for me. But a huge chunk of the participating communities were in this orange area that he's showing, but a big bulk of the impacts were in the blue area, which is the Cameron Parish, but only 7.5% who chose the buyout option were in this Cameron Parish, but they had 90% of the homes that were damaged, and not quite sure why that played out, which would be an interesting thing to know. And some of the just process aspects of the program, there was a pretty slow distribution of funds. The private company was trying to balance, efficiency with not having fraud problems. We talked about sellers being undercompensated. Part of that had to do with the $150,000 cap. There was a $40,000 penalty if a homeowner who opted for option 2 then couldn't find a place within Louisiana to relocate to. They took a 40% hit on what they were actually paid out. If they opted for option 3, they took that immediately. So there was some issues with just being penalized for being bought out. There was no vulnerability coordination, so they didn't really look at where their repetitive loss structures were, where their potential vulnerable areas were in terms of sea level rise impacts or levee failure in the future. So they weren't really targeting these funds to any future risk mitigation, which all kind of created a rebuilding in place bias. Okay, so Mississippi, moving on to Mississippi. So Mississippi also had large pots of money become available to it after the disasters, but they took a very different tact. they didn't engage in hardly any ad hoc acquisitions. Instead, they engaged with the U.S. Army Corps of Engineers to do a comprehensive planning process called MISSIP, Mississippi Coastal Improvements Program. So there was no buyout option. Instead, they really looked at, let's start planning, get a good plan for when we get hit again, and make sure that we're targeting these funds in a way that is directed towards, you know, the most vulnerable parts of our community. They looked at some conventional armoring approaches as well as a part of this plan, and they're also looking at risk-based acquisition, so how to direct that funding. And they came up with a multi-phase concept. So in the first phase, they're looking at acquisition or relocation of 2,000 structures, and in phase 2, they want to expand that out to 400,000 structures. The problem with this is that neither of these phases has been funded yet by Congress, so they spent the bulk of their money on the planning process and less on actual implementation. And so I don't know what it means by phase 1 and phase 2. Does that mean they have to be wiped out twice more before this gets implemented? But it's hard to tell because we don't know how yet this planning process is going to play out in the future. The one interesting thing about Mississippi is that they did do, as part of the planning process, a comprehensive environmental impact statement that was one of the first significant studies that had actual data that showed the economic benefits of acquisition can exceed the long-term maintenance and installation costs of protecting property in place. So they did do that economic analysis, and that's pretty significant. So David, in his planning hat, has also come up with some really great lessons learned that other communities can learn from this process. One thing is just to prepare a plan in advance of the storm so that when the storm does hit, you're ready and you can take that windfall of money that does become available to you and spend it in a way that actually builds your resilience in a smart, sound way. Another part of the Louisiana aspect that is interesting is the city did look in the initial phases of planning their rebuild process. There was a lot of top-down planning, and maps came out that showed areas as designated for retreat or open space. And once the public got wind of that, there was a huge political upheaval because they weren't involved in the process and there was no kind of bottom-up engagement. So this really has to be a community process. It can't be a top-down approach. So another aspect is to incorporate the spatial risks. Look at where your repetitive loss structures are. Look at where your potential vulnerabilities to sea level rise are. Look at where you want to have upland migration of wetlands and where you want to preserve buffers, flood buffers that can then protect your inland development. Avoid perverse incentives. So one of the aspects of the Louisiana program was that they were actually building in this rebuilding bias, and they weren't actually incentivizing buyouts over rebuilding. So how can you, if your goal is to buy people out and encourage retreat, the incentives have to match that goal. And then the last lesson learned is, and I don't think he's really giving a lesson here, is, one of the challenges trying to distribute very large amounts of money in $80,000 packets in a way that you can manage fraud and quality control, and that can be a difficult process, but some people in the Louisiana process had to wait up to 2 years to get their actual checks. And some tangential issues is, one of the problems that came out of Louisiana is when you're buying out property, and especially in a FEMA cost-effectiveness calculus world, there can be a high likelihood for discrimination against low-income communities because their land is cheaper to be bought out. So it becomes more cost-effective, but you can have problems with that. One of the issues we raised earlier is with the takings component, there has to be a accounting of what fair market value is, so that you're not, one of the biggest legal challenge to some of these programs is that you're undercompensating people to the point where it's not fair market value. Lack of participation was a problem. In Louisiana, what you got at the end of the day with this voluntary program was a checkerboard where you had some properties bought out and other people staying, so that can contribute to blight, and that also hinders your ability to restore floodplain function. And pairing acquisition programs with redevelopment and really shifting that growth and allowing people the opportunity to move upland and giving them the ability to do that. Thank you, and if you have any questions, direct them to David.
Okay, great. Thank you to our panelists, and thank you to Doug DeLuna and Alex Judd for helping to collect your questions. So we have a few. I'd like to start with the big picture. The question is, given political and legal expense realities, are retreat policies better developed by the states or by localities? And I actually want all three of you to answer this question, if you don't mind.
This looked like you were volunteering to go first.
Could you repeat the question?
Sure.
I just want to make sure I have it. Yes, it is.
Sure. Given political and legal expense realities, are retreat policies better developed by the states or by localities? So in other words, where are we which level of government is best equipped to tackle this problem in light of some of the challenges that we've talked about all day today?
So I think the state is better equipped. And the state is better equipped because it has the administrative capacity, it has the intellectual capacity to do the land use mapping, basically figuring out where the high-risk zones are. It has access to the universities where it can basically show which areas are most at risk of intense flooding, which ones can be sequenced later down the line. If you leave this to the cities and towns, then each city and town will have sort of an uneven patchwork, and all the cities and towns will have the impression they all need to act. I think actually it's going to be more efficient for the state to basically say these look like the areas of the coast or our riparian areas which are more at risk. Here's some of the state capacity we can bring to bear on that, whether it's transportation capacity, water, wastewater, rethinking where the infrastructure goes. I must say that I come from Rhode Island, which is an odd little state to say the least. And it's one of only 3 states in the U.S. that has a statewide comprehensive plan or a state enabling act, and that's very fortunate. So in Rhode Island, the state government has basically dictated that every city and town has to think about certain things. So we're fortunate in that respect, but I argue that the state is better equipped in all respects to undertake this.
I'm going to be a good lawyer and say it depends. I mean, I think if you're talking about state level mandates, yeah, you can get more bang for your buck that way because you can try to push that down in your locals. I mean, but given a political context, I don't know how realistic that is, especially in states where you have strong home rule. And I think it depends on what types of mechanism you're talking about. Dr. Karp gave a good discussion of like all of the realm of different mechanisms you can use to encourage retreat, and some are better implemented at a local level and some are better implemented at a state level depending on who has authority to do what. You know, you have essentially a lot of armoring policy, which is critical to any retreat policy, is administered at the state level, just given the public trust interest in the Army Corps program. So armoring policy, you know, necessarily needs to involve a state level entity, but where you have upland control of zoning and land use, and you're dealing with structures and removal of those structures, I think, you know, at this stage in the game, we need to think about local powers.
Okay, so we have states, we have it depends. Jason?
I agree. I think I'd probably defer to Chad. He may be able there.
Can we get a microphone over to I think you know.
That's awesome. So, sorry. So, Massachusetts is, we know Massachusetts better than we know Connecticut, and I think this is terrible. What am I doing? This is terrible.
Do you want to come over
I
here?
have to
We
walk
have
away.
an extra chair.
Sorry. Right, thank you. Sorry. So, I think it depends is probably a more logical solution for a state like Massachusetts that does have a strong home rule tradition. And I think the Massachusetts Wetlands Protection Act, which was discussed quickly, I think, by some of the colleagues at Harvard, talking about how that law, in the earlier session, at least in the question and answer, I remember them talking about the Wetlands Protection Act. It's a good example of how the state sets standards, not unlike if anybody's familiar with the Coastal Zone Management Act at the federal level, right? And then helps to incentivize the implementation of those standards at the local level. And I think that's probably, if we're looking at this kind of situation where a state can offer the opportunity to establish standards, in Massachusetts there's the opportunity for zoning overlay districts. 2 towns in Massachusetts have identified and developed their own zoning overlay districts, one in the Cape and I can't remember, I think it's Chatham, and the other one Oak Bluffs on Martha's Vineyard. And the specific purpose of this zoning overlay district is to manage adaptation to sea level rise. That's exactly why it exists. The tools that are available, well, that's important. And local decision makers get some pretty decent help from the state and also at the federal level. But I think that combination is ultimately where there's probably the best. So I think it's a mix of the two, to be honest with you.
Great. A follow-up question for Professor Karp in terms of the local level, because you're a fan of states. One of the things that, well, the question, I'll read the question then you can to address. So many Connecticut municipalities tax shoreline property owners at a high rate. Your recommendation is to add a risk assessment. Your recommendation to add a risk assessment is intriguing. Can we have it both ways? Talk about the power of localities to influence change through some of these things, like basic things like property taxes.
Okay. So cities and towns are, of course, enormously influential. Rhode Island, for instance, has 39 of them, and I've sat on citizen advisory committees and conservation commissions and so on. They're powerful and influential. And cities and towns can use that tax structure to both reward but also to send messages to citizens. So we have this wonderful use value taxation, which is a way of basically rewarding citizens for putting some of their property into conservation easements. Some in Rhode Island's a farm forest open space easement. Well, the reverse can easily be possible. So people who build on rapidly eroding lands or on steep slopes, the theory really ought to be the same, that if a property owner in fact is exposing the municipality to more risk or higher cost as a result of that individual behavior, the property tax is the right way to reflect that. Now, I have read coming into this meeting that a number of state level people have said there's so much development in Connecticut's coastal zone that armoring technology is really the only option here. There's too much wealth embedded within this area of Long Island to even think about retreat. And that's true that these properties in fact generate a lot of revenue, but for people who do what I do these days, we want to think about the negative externalities attached to that, right? So there are serious negative externalities attached with properties in the coastal zone. I think we're probably going to be seeing more, for example, contamination of drinking water supply, salinization of water supply. That means more spending on infrastructure. That's not going to happen at the municipal level. But I think states are going to have to require cities and towns to exercise some responsibility before the state has to bail out these coastal communities. So it's these coastal properties, they do add value to the economy, but they also have negative externalities that are not accounted for, in my opinion.
And I'd actually, sorry again, I'd actually like to kick this up to the federal level and pose a question to Jessica. So one of the things,
we have flood insurance question.
I think I might. So the question is, FEMA disaster funds will pay to rebuild as is, which may be a perverse incentive for communities wishing to re-engineer infrastructure with climate change in mind. How do we avoid this reverse incentive, or perverse incentive, either?
Are you talking specifically about the hazard mitigation grant program?
I think this question was more general. There's another question here about hazard mitigation, the program specifically, but I think we should feel free to address that.
Yeah, I mean, I think the tension that a lot of these federal statutes that intrude on what is traditionally seen to be the local domain of land use, the tension for the federal government is they don't want to intrude, so they use a carrot approach where they give the monies to state and local governments and they try to incentivize you to do the right thing with those monies. I think they could definitely put more strings on those carrots to encourage people to spend the money more wisely. But we have state and local people in the audience. I don't know how they would feel about that. I think there's, I think people like the flexibility of being able to spend money without kind of need counters telling them how to do it. So, I mean, we're looking at how federal programs can distribute their money in a more long-term sustainable way. But we also have to think about possible downsides of too much kind of intervention in.
So I actually give you a sense of where my true heart lies. I actually am a big fan of John Wesley Powell, who actually thought that the federal government should have a very strong hand in land use, and we should be reorganizing the way we develop around what infrastructure exists. And that said, I'm going to give you a quote about the National Flood Insurance Program, and it's a quote from a book called Losing Ground, A Nation on Edge. And it says, the National Flood Insurance Program is an actuarial joke. It would be like having a federal auto insurance company that only insured teenage boys who drink and drive. By definition, the properties covered by the program are doomed to be flooded, damaged, and even destroyed, not just once, but time and time again. And I would say there's a federal role here. And I read a study coming into this talk that said something like only 18% of the property owners who are eligible to receive or eligible to be part of the National Flood Insurance Program actually pay their premiums, because as soon as a storm event has gone past, they say, well, the risk of this happening again are remote, because people don't really understand anything about risk. And that's why I strongly suggest we need some mandatory, either mandatory insurance or kill it. Make it unavailable so people have to pay out of pocket.
Yeah, I mean, I think there's a difference between the flood insurance program itself as it's administered by FEMA and all the perverse incentives that creates versus, how that affects land use. And do we need FEMA to tell us how to regulate the floodplains better, or do we need FEMA to manage its own house better and set actuarial rates in an actuarial fashion instead of subsidizing insurance for coastal areas? And then a separate question from that is, how are they spending these emergency relief funding and the funding that becomes available to communities after a storm to rebuild? And those all have, different calculus.
Yeah, and this is a topic that we're going to explore hopefully in future years with our Center on Insurance Law in combination with our Center for Energy and Environmental Law here at the law school. But I think the insurance component, whether it's the flood insurance program or private insurance, is going to be a really increasingly important area, which I think we here in Connecticut are particularly well poised to address. But moving back to the questions, how about this one? What is the future of for the high tide line? Is it a taking to? I think the question is about anticipating a future high tide line. In other words, how do we? And I mean, if the high tide line is changing, where we think the taking will occur will change as a result. I don't know if you wanted to address that one. I guess how do we incorporate the fact that high tide lines are changing? I mean, as we heard from the science and some of the others. I mean, anybody should feel free to address it. Sure.
Yeah,
So
I have something good to say.
I'll let you deal with the public trust aspect. I actually want to give credit to an old friend of mine, Clayton Pennyman, who I hope is still in the audience. Clayton, are you here? No? So an old friend of mine, Dr. Clayton Pennyman, who was here a minute ago, I asked him how mean high tide is defined, and it's defined on an 18.6-year frequency, and it's defined by the National Oceanic and Atmospheric Administration, so it's defined by federal law. So there really is a federal definition of mean high tide, and it just got redefined. So there really is a very recent definition of the average mean high tide. New Hampshire, by state law, adopted the law that the highest rack line represents mean high tide. And for the purpose of what the public understands, I mean, you might imagine if any of you ever go to the beach, what do you think the mean high tide is when you walk on a beach? Any of you who are beachgoers, it's the rack line that tells you something about high tide. And that really, to me, is a prudent rule. And in terms of understanding how we adapt to that, if the public trust doctrine addresses everything below mean high tide, it does in Connecticut, it does in Rhode Island, Massachusetts is below mean low tide, then you basically can follow that rule. Because that also helps you figure out what goes on with houses that are sitting there on the beach right at mean high tide. You can tell whether it's intruding into this property area that's governed by the state.
Excuse me, that was my question, and I apologize for not wording it right.
Oh, sure. Sure,
I'll just yell if you can hear me.
no, we'll wait till
All
we
right.
get the microphone because I think we're, and then we'll come back to Professor McGuire and Ray.
I apologize for not wording the question as clearly as I might have. My question really is, can we base the mean high tide on a model at some future time so that we can write regulation now or zoning ordinances now based upon that future high tide? Maybe it's 20, 30, 40 years from now where that's going to be.
I think we should, we'll pass the mic over to Chad.
The answer is yes.
I think it's walking away. So I think in some ways, minimum setback requirements that are being implemented under zoning overlay districts, they're doing it by the average erosion rates. So certain states are doing that, and implicitly what's going on there, if we think about it, I think it's connected to your question, which is they're forward thinking that the high tide is going to be based on erosion rates, right? 30 years from now, way up there, or whatever it is, right? Rise over run. So at some point in landward. So I think to some degree there's a bit of that. I just wanted to make a point about the property right, basically what we thought your question was, if I can add to that as well. So the point is, what I was thinking immediately based on your amended question is, I think there is some policy moving in that direction. The clear indication of that is basing minimum setbacks on erosion rates. Years, so the setback is based on, I think that the water will not hit the house in 30 years, right, if you build a house at X distance based on what we believe historical erosion rates are. Now that might not be helpful in a dynamic scenario where sea level rise grows faster than we expect historically, but that's a different question. But from a property rights standpoint, it's interesting to think about, well, what happens when the high tide line, whatever that division line between essentially public ownership, right, the submerged land, and private ownership. Well, if it moves landward, I mean, to answer the question that Sarah had sort of stated at the beginning.
I
interpreted at the beginning, I mean, that obviously becomes, in my opinion, that becomes public land. So if the high tide line is moving landward, that's just public land, and it's public land by definition. And the reason I want to highlight the property rights, if you can think about it, it's a little difficult conceptually at first, but if you think about it, when government's acting in its regulatory role, it sort of sits above us, doesn't it? We look up to government. Government's over, like an umbrella, and it tells us, and it's interpreting law, it's creating law, it's legislating, it's then implementing, legal policy. But when you look at government as a property owner versus my rights as a property owner, it changes the dynamic. It does. It literally changes the way in which that relationship's created. So a government enforcing its property right as the high tide line might move landward, is very different than a government creating a regulation saying that's all mine up front, or in other words, you can't build in areas I think might be mine in the future. And so it creates a very different way of looking at the relationship. And the reason I say that is because we come from a premise, the way Jason and I have been looking at this issue, is that you can control structures, but you cannot control process. And that might take a while to understand, but what I mean by that is, when you think about creating good policy, you can establish structures, but you can't establish necessarily how those structures will be dealt with in the process between parties, like how money will be distributed, right? So you can establish the structure of giving money for rebuilding, but you can't necessarily know how well that money will be spent, right? Is it spent entirely on the sort of overview phase? Or meaning that, how are we going to implement this plan in Mississippi versus are we actually paying out? Does it mean anything? So when I think about the law giving us structures, I think about the difference between our structure from a regulatory standpoint, how the government acts, right, versus the government as the owner of property or its public trust obligations as a trustee of public rights. Very different way to look at it, but so I just wanted to make that comment if it wasn't made clearly during the presentation.
On the takings issue, I also think there's a temporal aspect that should be brought into the equation, because in a lot of cases we're not dealing with these, in the sea level rise adaptation setting, we're not going to only be dealing with these extreme events where we're having mass wipeouts. We're going to have incremental loss of land over time, and local governments and state governments in the regulator role are in much solid footing if they set those regulations in place in advance of impacts, where that landowner can still reap some economic benefit and use out of their land, but you're setting in that expectation that, you now are subject to these shifting timelines, and you're setting in those regulatory expectations. So then when nature does gradually take that land away and that land becomes somewhat condemned by nature, you've laid more of an expectation of your landowners that is what's going to happen to them, and courts in the takings context value that.
If I could just very quickly, I want to go back to this question, which really has to do with the extent to which governments can anticipate risk and then basically start to develop rules and regulations with respect to that. And I want to point out that the National Flood Insurance Program, the NFIP firm maps, so the flood insurance rate maps, that assign these different codes based on the risk of flooding or based on the risk of storm surge, are based on the 100-year storm, or the probability that that property will have a flood event or a storm surge event each year. And if it's 100 years, it's 1% a year. The climate change people are saying that we should already be anticipating that those rates should be thought of as more like 66 or 33% years, so that we in fact might triple or more the frequency of those storms. And so what South Carolina has done, just to give you an example that this is possible, when they issue a permit to a new person, they say you must develop inland either 30 times up to 90 times the setback in rapid erosion areas. And it's erosion based, it's not just flooding based, but you must have a setback that's the equivalent of somewhere between 30 and 90 times the anticipated erosion rate over the life of a 30-year mortgage. All right? That's reasonable, because then your insurers, your banks really ought to want to do that. And it's getting your private sector to think out, okay, you're going to give somebody a loan here. What's the probability that person's going to actually have a house standing at the end of 30 years? So yes, you can do anticipatory risk management like that. You can do it through the private sector or the public sector.
Thank you. I have one last question, but I think it'll generate some interesting responses based on these really great papers. So we started with a big picture question. We're going to end with a big picture question, which I hope everyone can address, and that is, what is the best way to freeze development without risking a takings challenge? So, I mean, we've talked about the limitations, but now, and you've given us some recommendations, but give us the best of the best, and I'll start with Jason.
Okay. Well, I think it really goes back to sort of the main points that I tried to make, and I think to freeze development, I think it really starts in the stance that the government takes as far as before it chooses to freeze development in a certain area that may be at high risk of erosion or whatever the case may be. I think that if their stance is rooted a non-regulatory stance, and that their reasons for freezing development are based upon their property ownership rights and their trustee obligations that, you know, I think basically the main points we were trying to make. I think that if they can do that as a basis, as a preliminary stance, that then the outcome is likely to avoid the successful challenge in taking this analysis.
Okay, thank you.
And so I actually would say that all the GIS, Geographic Information System people in the room, here's what I do. I would get the state to map all the lands that should be thought of as unbuildable over the next 50 to 100 years. And I would really come up with a statutory definition of unbuildable lands. And unbuildable lands already under federal law would include wetlands, and I'm sure you have an analog in state law that says tidal wetlands, freshwater wetlands are unbuildable, and we're going to define those lands this way. Barrier beaches, unbuildable. Steep slopes, unbuildable. Lands exposed to extreme erosion events, unbuildable. Lands in the 100-year floodplain as projected out 50 to 100 years, unbuildable. It, to some extent, insulates government from takings claims because the government is charged under the 10th Amendment with protecting public health, safety, and welfare. So to the extent the government is acting to do that, and it is basically saying we're trying to protect adjacent property owners, large public interests from all sorts of contamination, it's within the government's right to do that. That almost certainly has to be implemented or enforced at the local level. It gives the local level something to stand on. You probably don't want the local governments identifying unbuildable land. They're particularly subject to political pressure. So I think in this case it is a top-down thing to do. And it's technical. So it's the kind of thing that is capable of some kind of reasonable identification where you can actually have people reproduce the effort.
It's incorporating science into law, novel concept. Professor Kranis.
I think, I mean, as my students pitched in their talk, that this is going to be a long-term struggle. The political challenges are huge. The economic, costs and benefits are large and uncertain. So I think it's going to take a coupling of the whole wide range of tools. I think putting it in regulation now, to a certain amount of regulation now, locks in those landowner expectations that you need over the long term, ensures that you're not spending out huge amounts of money to buy out every vulnerable property owner along your coast, because you can't do that. It's ensuring that you're not going to completely armor your coast. I think you need to also build in those anti-armoring policies, because if you don't have an anti-armoring policy, why have a retreat policy? And I think you need to think outside the box a little bit and look at transferable development rights programs, because they have been sanctified by the courts as a way to sort of get around the takings challenge, and that can be part of the economic value of your land if you can sell it to someone else. So transfer development right allows you to basically monetize your development rights in the land and sell it to somewhere upland where someone else can use it to build density in a safer part of the community. And that also allows the community to not lose that tax base because they're just shifting the development somewhere else. But I mean, that's not a fail-safe solution. It's difficult, if not, it's a difficult administrative thing to put into place in the first place, and it's relatively untested in kind of coastal areas with high land value. So not give you any hope, but I think it's going to take some experimentation and trying to see where you can couple all of these different tools and use incentives and regulations in creative ways.
Great. So I hope you'll join me in giving a hand to our panelists. I know there were. I was glad that we had a little bit more time to get to all the questions, but I assume they're going to hang out for a little bit if you had anything else to ask. We'll file off and closing remarks.
Hey, where are y'all going back there? Well, how's everybody doing? Are you ready for more? Raise your hands. It does feel as if we've had a fire hose party here. A lot of information coming at us all at once. But what a terrific day. I think it's important to, well, first of all, my name's Adam Welchel. I work for the Nature Conservancy and very happy to be amongst the advising committee for this particular event. So as Joe indicated at the beginning of the day, this truly is a unique event. This is a unique exchange with a unique audience. We have a pretty wide selection and variety of people here, and it's very exciting to not only learn and listen from the experts, but also ask questions. And it's very obvious to me, and I hope others, that the quality of the questions here is pretty remarkable. I think we've got a great group going forward here. So we've pulled back the curtain on this issue of legal solutions and our coast. We've got greater and growing clarity, which is important. And we've got a lot of people to thank, so let's do that right off the bat. How about that, Seema? First and foremost, let's get out of there without you. But of course, we had a wonderful senator. Senator Blumenthal was here today. We had Tony McDonald with his inspirational comments this morning. All of our speakers and all of the folks in the audience here, our advising committee, the organizers, Joe and Seema, and of course the University of Connecticut School of Law for hosting this event. This could not have happened without all of you. And I sense we've got a growing community here of folks that are very interested in this issue, and we'll see how far we get. So I think it's abundantly clear today, based on some, particularly the last talks, that this is a particularly sensitive issue. This is an issue that affects lives, livelihoods, communities, economy, equitability, ecology. This is a comprehensive issue. And I remember spending some time with an old, wise lawyer who walks around in regulatory clothing. I think there's a few of you guys out there here today. But he described for me probably the most challenging place to work in the world. And see what comes to mind here. It's rather obvious. But where do we have the greatest concentration of wealth, investment, and people? Where do we have the largest intersection and overlap of jurisdictions, regulations, and policies? Where do we have the world's most productive ecosystems in the world? Obviously, it's the coast. We're talking about the coast. We've only picked the most challenging place to work in the world. So fortunately, we have things like this. But underneath all of the presentations today, I think there is a notion that there is some change required here, and the idea that we need to rethink or redesign the edge that was used today, this coastal area, if you will. However, what I heard today, or perhaps chose to hear today, was that we are certainly not alone here in Connecticut. We ask all these wonderful people to tailor their perceptions and their thinking and their academic pursuits to Connecticut. And what I chose to hear today is that there are options and this is doable. I think it's really important to weigh on the side of optimism at the beginning of this process. So, we are in the early phases of this. There's obviously a lot of work ahead. What we've started today is a proactive step in the right direction that will ultimately improve our collective decision-making ability. One thing is clear, that we are human, and we often make better decisions when we plan forward versus making decisions in crisis. We can learn from those mistakes, obviously. Today we have gathered and benefited from the wonderful experts, and as well as your collective input. It's a good start, but we all need to continue to play a role here. And it's obvious that there are quite a few people in the audience that are committed and connected and integrated in a lot of different activities. And I'll just start with those working in the state of Connecticut here that might be connected to the following activities. We recently had a two-storm panel, which was a significant discussion and dialogue, perhaps not directly on this issue, but it was a dialogue around hazards and how do we plan and prepare for the future. We have a wonderful, hopefully new startup here for the state of Connecticut, the Sea Level Rise Task Force. I believe that's what it's being called. Representative Aldis is in the back. We also have a large number of efforts around revisions and updates of the state plan of conservation and development, the translating down to the RPO as well as the municipal level. Also, regional municipal natural hazard mitigation plans, we can't forget those. Any major infrastructure projects, Senator Blumenthal mentioned our port facilities and thinking forward about the completion of the Panama Canal in 2014 and how do we position ourselves locally to be in a good, to receive those goods and benefit from that economic prosperous activity, but how are we thinking about sea level rise in our port facilities and the expansion, etc. High-speed rail, public health, natural resource management, and of course the private sector. We did have some private sector folks here today, and we spent some time talking about the insurance. So the idea here is to take and gather what you've learned and look for ways to have a conversation with somebody that's not here, or look for ways that you can start this dialogue in your daily practices so that we benefit from discussions around future hazard events, sea level rise, those kind of things. And those of you that are visiting the fine state of Connecticut, you have an opportunity as well. We have some federal agency representation, which is always good to see. And we need to absorb what we've gathered here and report back, and not only in our place of business, but also our local communities. We are at the beginning of this, and enough dialogue. This will be doable. This will be doable. We have to remain optimistic and flexible. These were positive notes late last night, but I thought, let's say it again and again and again and again. Let's reflect back on some of the words that Tony left us with. Let's make it real. We know enough now to take action. It's what simply must be done. Wonderful words. Let's see. Oh, as a quick reminder, that's the end of my concluding remarks, but I wanted to, for the benefit of all, I wanted to mention, and of course correct me, see if I'm off base, but this is obviously being recorded. I can see the guy back there. And it will be available to all comers at some point in the future.
I don't think we figured out how we'll make it available, but it is being filmed and we'll figure it out. So we can,
websites.
We could probably, if you're interested, get with CDM or whatever DDM. And I am putting the PowerPoints online too, so you'll all have access to the PowerPoint shortly.
And SEMA has all of your email addresses if you didn't know that already. And of course, this will all be wrapped up with a pretty bow in a special edition of the Sea Grant Law and Policy Journal. This coming soon to a library near you. One final reminder, you really need to write down your priority notes. There's pads of paper. There's a suggestion basket on the way out, the back page of the flyer there. This really is about getting input, two-way street, having your collective wisdom and reactions to what you heard today. We need to have that. So as one final note, as with all good things, they must come to an end. On behalf of the advisory committee, unless you want to do another panel, Seema, you ready? On behalf of the advisory committee, the organizers, the University of Connecticut School of Law, if I may, and the sponsors for this particular event, I would like to extend a sincere thanks to all of you for being such a wonderful group of participants. Travel safe, come back anytime, and how about a big round of applause for everybody?